Hello, welcome to our third episode of our new program, Know Your Land and Environment Rights, brought to you by Witness Radio Uganda. I'm Rita Abavide, and I would like to assure you that we shall be bringing you more episodes in line with Know Your Land and Environment Rights program. We would like to thank you for tuning in to Witness Radio, hashtag Know Your Land Environment Rights program. Just a short recap of what we discussed in our second episode. We discussed about the history of land management in Uganda, starting from the pre-colonial era to the current years. And today we would like to discuss a new topic, and that is laws that are governing land management in Uganda. I have a special guest today in the studio that is going to hint and explain more about these laws that are governing land management in Uganda. You are very welcome.
Thank you, Rita, and thanks to our dear listeners for staying tuned in. My name is Bulirali Joan, and I'm delighted to be given this opportunity to sensitize the citizens of Uganda about their land and environmental rights, because I strongly believe that the reason why we're having high rates of land evictions in Uganda is because a lot of Ugandans are illiterate and they are ignorant about their land rights. So thank you, Witness Radio, for the platform. Thank you, the host, for giving me this opportunity to share knowledge with other people. Thanks.
Thank you, Miss Joanne. We are so glad to have you at Witness Radio, and our listeners out there are very eager to hear from you. But before we continue, let's go for a short commercial break. We shall be back.
Nebwendi ekikomando nkimanyi mbulidde ekikomando naye nzira waffe naye kati bamenye nzira ku streeti bazira ku streeti okitegeera nzira ku streeti bangenda kubba
agenda batya okukijingirira oba bakikola batya tetwamanya tugenda okulaba nga kakande azze ne fayiro nga batugamba nti yaguze ettaka kwaffe yaliguze kwani ettaka lyaffe.
Witnessradio.org changes all of that.
This is Witness Radio, connecting indigenous and local community voices.
Listen to Witness Radio and gain knowledge about land and environment injustices by communities.
Welcome back from that short break. Thank you so much, Miss Joanne. And a big thank you to our listeners for tuning in. For comments and feedback on our program, you can email us at radiowitnessradio.ug. Send us a direct message on our X handle, formerly Twitter, at Witness Radio, or call us directly at 041 469 7221. We value your input. Before we went in for the break, I told you we are going to discuss about laws that are governing land management in Uganda, and Miss Joanne is here to explain that. Thank you, Joanne.
Thank you, our host, for once again giving me this opportunity to share with people out there about their land and environmental rights. It is really a pleasure for me to be at this radio to share knowledge with other people. I really do appreciate. Well, today we shall focus more, or we shall put more emphasis on the laws that are governing land management in Uganda, a few laws that are governing land management in Uganda, and probably those that we shall have. We may have not discussed this episode. We shall also discuss them in another episode. Well, today we are starting with the 1995 Constitution of Uganda, because it is the supreme law where all other laws derive their validity from. So that's why we are starting with the Constitution of Uganda, and we want to know, what does the Constitution say about land ownership and management in Uganda as of now. We shall start with probably Article 237 of the Constitution of Uganda, that states clearly that all land belongs to the citizens of Uganda and shall vest in them by the land tenure system provided for this constitution. The tenure systems that we all know, the customary, leasehold, milo, and freehold. It goes ahead to say, to provide for the fact that the government or the local government, as determined by the parliament, shall hold in trust for the people and protect natural lakes, rivers, wetlands, forest reserves, game reserves, national parks, and any land to be reserved for ecological and touristic purposes for the common good of all citizens. It also gives us ways of how a non-citizen may acquire land, and that is only through leasehold tenure system. They cannot acquire land in any other way in Uganda. It stipulates very well under Article 26. It stipulates very well that all land in Uganda shall be owned through the following land tenure systems that I've briefly described to you, which are customary tenure. And this is a type of land tenure that applies to a specific area of land or a specific description or class of persons governed by rules generally accepted as binding and authoritative by the class of persons to which it applies, as it is well stipulated under Section 3 of the Land Act that we shall also be talking about later in this same program. It also gives us that a person can own land under freehold tenure, and this is a form of tenure that involves holding registered land in perpetuity. Like you have a land title that speaks to your legal ownership of that land, and no other unregistered interest on land can actually challenge that kind of land tenure system. We have the Milo tenure. This is a type of tenure where it involves holding land in perpetuity, though it permits the separation of ownership of land from ownership of developments on land made by law, by lawful or bona fide occupants. Under this under Milo, that's where we have the Bibanja holders. So we have a landlord and also Bibanja holders under this, and it basically works in Buganda, in Buganda land or in the central. And then we have also the leasehold. And under leasehold, this is where people own land through a contract. You own land for a specific period of time, you know.
Madam John, I'd like you to elaborate more on leasehold.
Leasehold tenure, this is a kind of land tenure where you find that it's usually, we have also Ugandans actually acquiring land through leasehold, but in Uganda, it's the most dominant people that are owning land under leasehold tenure are non-citizens, because they do not have a right to own land in any other land tenure system. So under leasehold, a person actually owns land. It's like a contract of owns land for a certain period of time. Yeah, for a certain period of time. Let's say they can be 5 years, 10 years, 99 years, but it has to be for a certain period of time. And if a person that owns land under leasehold has a right to do anything they want on that land, and nobody has to deprive you of your rights to the interests of that land under that land tenure system before the years that you are granted to have interest on that land elapse. So you own land like any other person, like in any other land tenure system, like freehold, you know, and you have a right to do whatever you want to do on that land for as long as your time frame for occupying that land still runs. And it will elapse after the years that you agree to occupy the land also get over.
Okay.
Yes.
What I would like also to know is that is it only applied to the citizens and or to the non-citizens?
No, we have usually it is the non-citizens that are actually using this kind of land tenure system, but I can assure you we have also citizens acquiring land in that same tenure system. So it is not too specific, but the reason why the constitution says non-citizens can, like it's the reason why it emphasizes non-citizens can is because for them they cannot actually acquire land in any other land tenure system apart from leasehold. But we have seen also citizens acquiring land in that same land tenure system. Yes.
Okay.
So with us knowing that actually everybody has a right, or everybody has a right to own land in Uganda as long as you're a citizen, in accordance with the land tenure systems that I have stipulated below, that have stipulated, still the government also has a right. There is an exception under Article 26 where the government has a right to actually acquire land, especially when it is for public interest, So it acquires that land, probably if it wants to establish a school, or probably if it wants to do build a hospital, or for roads and all that.
For as long as it's for public.
Yes, for the public interest.
Okay.
So, but even when it is actually acquiring that land, there must be consent between the government and the landowner. And
yes.
there must be also adequate compensation. They must compensate them for the interest, for the land and the assets on the land, the property. And it must be adequate compensation, not just giving them some little money. It's just because the government wants to take, land. Yeah. So it must be adequate compensation. So the government also goes ahead to also talk about, to provide, it also goes ahead to establish bodies that it feels through the Constitution. The Constitution goes ahead to provide, to provide for bodies that can also help to run, to smoothen the land management system in Uganda. And we shall look at, when we look at Article 238, it provides for the establishment of the Ugandan Land Commission. And the Ugandan Land Commission here, this one basically governs land that belongs to the government, only basically governs land that belongs to the government. And the Land Commission, it has a chairperson, and it has not less than 4 other members appointed by the president with the approval of the parliament, So it basically looks at administers land that is under government under government control or use. Yes. So that is what that's its function. That is why it was established in Uganda. Okay. So it also goes ahead to also establish land committees, also the district land boards, and these ones function. Their function is to hold and allocate land in the district that is not owned by any person or authority, facilitate the registration and transfer of interest in land, and deals with all other matters connected with the land in the district by laws made by parliament. So we also have that establishment of the district land boards that help in administering land at district level. So all those bodies were put there to help to smoothen land management in Uganda. You get? We also have where it provides for the land tribunal in Uganda, and this land tribunal, its main purpose is it determines disputes relating to land, especially relating to lease, repossession, transfer or acquisition of land by individuals. So the Land Commission, other authority with responsibility relating to land. So these bodies are there to smoothen the administration of land ownership in Uganda. The Constitution clearly states that all these laws, it also goes ahead to state that it vests powers in the parliament to also enact laws that will actually help in the management of land in Uganda. And it is through this Constitution that these laws operationalize. You get me? So with the laws in Uganda that were implemented, that were enacted to help in the administration of land in Uganda, apart from that derive their validity from the Constitution, we have the Land Act of Uganda. This one provides...
Miss Joan, before you go ahead.
Yes.
You mean this Article 243
yes.
only applies to government?
Yeah. The Land Commission only helps in the administration of land that is in government use. So it only administers government land, not any other land. And you find that it's the district land boards that help us to administer land at individual basis. Yes, so that is what happens.
Okay.
Yeah. And the district land boards are also independent. They do not have, when they're making decisions, they do not have to rely on what the land commission says or does, So that is what they do. Okay. So I think we shall go on and discuss about the other laws that are that help in governing land management in Uganda. One of them being the Land Act of 1998, which is amended to a Land Act of Cap 2227. This one provides detailed regulations on land tenure, management and dispute resolution, protects lawful and bona fide occupants, and it also establishes land tribunals. The Land Act, as you know, it has 6 chapters. We shall briefly describe what each chapter entails, and then later on we shall dive deep in what each law that is described in each chapter actually caters. So for today, we shall just give a brief summary of what each chapter or what the Land Act entails. And then in other episodes, because this program is still running, we shall be able to discuss more about the other topics deeply.
Okay, sorry to cut you short.
Yeah.
This Land Act of 1998, does it still govern the Uganda Land Commission?
Yes.
Okay.
Yeah. So whatever the Land Commission does must be abide by the laws that govern land management in Uganda, all laws. So it is not supreme to other laws. It has to abide by all the laws that are governing land management in Uganda.
Despite the fact that the government...
Exactly. That is why if the government is acquiring land, it must follow the rules of the Land Acquisition Act of adequate compensation, consent of people. So all these bodies, whatever they do, they must make sure they abide by the laws of Uganda that are governing land management or land governance, yes.
Okay.
So now we shall go to the Land Act of Uganda, like I said. The Land Act of Uganda, it has 6 chapters, and the first chapter, it talks about holding land in Uganda, and in it, it describes land ownership. When it talks about land ownership here, it gives the fact that land in Uganda belongs to the citizens of Uganda. Yes. Yeah, it talks about the instance of the forms of tenure that people have to own land in Uganda, talking about the ones we talked about, the freehold, leasehold, customary. Yeah. So it also talks about the customary tenure system and its registration. You know, these days now, the people who are owning land under customary tenure can actually register and get the customary certificate of title. Yes, so it also talks about rights of women, children, and people with disability, especially regarding customary land tenure system, because that is where women are undermined. Their rights of ownership of land are undermined. So it talks about them. Under that, it also talks about conversion of leasehold to freehold. It talks about bona fide occupants, you know. Yes, it also talks about, it discusses about tenants by occupancy. Tenants by occupancy here, they're meaning vibanja holders, you know, trying to bridge a gap between landlords and tenants.
Yeah, somebody out there might not know the bona fide occupant.
A bona fide occupant is a person that has been on land for more than 12 years without disturbance from the real owner of the land. Okay. So they do not know who the owner of the land is, and have been on that land without being disturbed by the owner of the land for 12 years. And that works, it works better even, it used to work better if you occupy that land before they're coming into the Constitution, the 1995 Constitution. Yes, so there is nothing they can say about it. So that is who a bona fide occupant is.
Okay.
Yeah.
Thank you.
So it also gives ways of how a vibanja holder can pay ground rent, and also gives grounds as to when a landlord can evict someone off their land. And it also gives the fact that the only way a landlord can evict a chibanja holder is maybe for non-payment of ground rent.
That ground rent.
Yes.
Yeah. What is it?
The ground rent. This is kind of money, or busulu, that is given to a landlord by a tenant. A tenant is a chibanja holder. Yes. That has been on land for that. It works especially when it comes to Milo tenure system. So this one only applies to Milo tenure system, you know, where people, where we have the landlords and the tenants are the vibanja holders. Yeah, so that is when they have to pay ground rent, which is obusulu. And please, we encourage everybody, every chibanja holder, to please pay busulu, because if you don't pay that ground rent, then the landlord has a right to evict you, you know, from the land for payment, for non-payment of ground rent.
Hope our listeners are following. Before Miss Joanne continues, we are going in for a short commercial break, and we shall be right back.
Witness Radio, uniting local voices in land and environmental justice struggle.
Amanya nze Lugambiso Robert, tuli basanyufu olunaku olwaleero twebaza Witness Radio olw'okuba nti ezze wansi eno gye tuli gye tuwangaalira gye tusanga ebizibu eby'enjawulo naye nejja okuba nti nno yongera okuwuliriza ebirowoozo byaffe ate nga si lwalero lwokka kubanga ebadde jantakera ng'etambula ng'ekola pulogulaamu ez'enjawulo abantu ne bawulira amawulire ag'enjawulo ne basobola okuba nga bayambibwa mu ngeri ezitali zimu okusingira ddala ku by'obutonde bw'ensi. Obutonde bw'ensi nawo tulaba nti bukyusekyuse, embeera y'obudde ekyuse olw'ensonga y'emiti okuba nti no gisaliddwa. Amakampunizi gasimbyewo ebintu eby'enjawulo, ekalangala basimbyeyo ebinazi, ewala basimbyeyo payini, basimbyeyo biki, naye nga basaanyayo buki obutonde bw'ensi obwaffe bwe twasangibwa nabo.
Witness Radio.
Witness Radio.
Witness Radio.
Witness Radio.
Listen to Witness Radio and gain knowledge about land and environmental injustices by communities.
Welcome back from that short commercial break, and I am your host Rita Bavide. Hope you are still on track because I do not want to leave you on the way. But before, I would like to take this opportunity to inform you, our dear listeners, that if you are facing challenges related to human rights, land or environment issues, you can report to us directly using the USSD code, that is star 284 star 444 hash, or reach out via our WhatsApp number 0745 965765. And as well, you can use your Play Store to download Witness Radio app to listen in live to all other programs of Witness Radio. Before we went for the break, Miss John was explaining something about land holding in Uganda under the Land Act of 1998. Miss Joan, you're welcome.
Thank you very much. Please, our dear listeners, we thank you for staying tuned in to this program. Hope we benefit from it and it serves the purpose as we had planned. We are still actually discussing the Land Act as amended, and now we shall be looking at Chapter 3, which provides for control of land use of the Land Act. Chapter 3 of the Land Act provides for control of land use, and under this it discusses about acquisition of land by the government, where we said the government can acquire land for public interest, but it has to follow the laws that were stipulated by the Land Acquisition Act, where there must be adequate compensation and consent from the landowners. It also talks about utilization of land according to various laws. It talks about control of environmentally sensitive areas, land use planning and zoning. This is where also NEMA comes in, where people are not allowed to actually settle in a wetland or establish any business or anything in a wetland or a swampy place. So this is where all these issues fall. We shall also look at Chapter 4, which provides for land management and use. And under land management and use, here there is establishment of the Land Commission, of which I say that one is hopeful in the administration of government land, and it also describes its functionality very well. And this, like I said, we are just giving summary of what each chapter talks about, and we shall dive deep as we proceed with this program of what each law and what each body and which works for what. It also provides for establishment of the district land boards and its functions, and it also talks about the land committees and also their functions. So all these things, you can find them in Chapter 4 of the Land Act, which talks about land management in Uganda. And all these bodies were established to make sure there is smooth administration or land management smooth administration of land management or land ownership in Uganda.
Before you continue, I'd like to ask something. You said the government is allowed to acquire land comparatively or under a certain act or
The
law.
government is
Yes.
for public interest.
Yes.
It has a right to acquire land for public interest.
What happens if the government does not fulfill the required the required compensations that are supposed to be given to the landowners?
Well, I believe a person has a right to report to court.
Yeah. Do they have a law that protects them?
Yes, the laws are very clear. Like the law says, you must adequately compensate someone if you're taking land from them.
Okay.
So even the government is bound to follow the rules or the laws when it is acquiring land from a citizen of Uganda. So in case there is any breach of the law, then the person that has been affected or the victim has a right to go and report to court and file a complaint in court. You get it?
Yes. I get.
Yeah. So even the government is not above the law. It's not above the law. So in case it acts contrary to the law, they can be held accountable for their actions.
Okay.
Yes.
That only applies to theory. If the government is not above the law, that only applies.
I
theory.
understand. Yeah, the laws are there, but the practical bit of it is different.
Yeah.
But what to do? Like we are trying so much to make sure that actually, the reason why the government has also been taking advantage of that, and the laws end in the theoretical bit of it, and they do not apply practically, is the fact that also people are being ignorant about the law.
Yes.
So if they know, it is also easy for them to say, my dear, I have my rights and you cannot take them away, and they know where to go in case their rights are being infringed by any person.
Yeah.
Yes.
Yeah. So we've seen so many cases that have come up because the government continues to violate these laws and oppress the citizens. However, you can continue.
That's a very good discussion, and I think as we move forward, we'll have to have a discussion on that, because for crying out loud, we know, like even where the government or the parliament or laws have been enacted, in so much to see that there is equality. There is equality in land ownership in Uganda. We have still seen people's land rights being violated, and it breaks our hearts when we see the government actually taking part in such human rights violations. It really breaks our heart. That's why, to some extent, we see people now or organizations that have helped people that have been evicted of land. They go beyond actually filing cases in court, and they have to use international avenues of getting redress for the citizens of Uganda whose land rights have been violated. That's why you see people now are filing complaints to, accountability mechanisms to see that, people get justice, because we know in Uganda here it will take you time to get justice for those people.
Yeah. Okay.
Yes.
Okay.
So in chapter 5 of we are still talking about the Land Act. We haven't gone to any other law. Chapter 5 of the Land Act provides for the land tribunals and its functions. The land tribunal is usually it's there to solve the disputes on land that happen, because there are a lot of disputes happening on land. So if a person feels like they have been deprived of their land rights, they can actually lodge a complaint with the land tribunal, and then probably issues are settled there. And we shall be discussing further, or we shall deep dive in the function of the land tribunal as we move forward in this program. That is all we had for the Land Act. That is what the Land Act actually stipulates about land ownership in Uganda. And now we shall have to look at another law, which is Registration of Titles Act. And the Registration of Titles Act here, it basically governs the registration of land interest under freehold, leasehold, milo, because those are the land tenure systems that and customary land tenure systems that are recognized in Uganda by the Constitution and all other laws. So now this year, it gives procedures that people must follow to register their land and get legal ownership on the land. Under this act, act is a very key species of legislation in Uganda that governs the registration of land and the systems of land tenure. And in it, we have also given a summary of what it talks about, what is entailed in the Registration of Titles Act, we are going to give you a brief summary of what it is about, what laws are in there, and their functions. So do not worry. We might be we'll dive deep into these laws as the program goes on. Here in the Registration of Titles Act, we talk about the torrent systems of land registration, and it establishes the registrar of titles, whose duty is to maintain the registrar and oversee land transactions. So there is a land registrar, that helps in the registration and the transfer and the transfer of land ownership, in Uganda, and he oversees land transactions that are happening in Uganda. So the main reason actually why we started this program, we wanted to sensitize people on how they can register their interests on land, so that we realize these investors that come over bullying, especially people that are on customary land, and then Milo owners, because most of them, their land, they do not have the legal ownership. Their land is not registered. So that is why actually we initiated this program. So it governs registration of land in Uganda. This act also governs the process of registration and the issuance of certificates of title, which provides conclusive evidence of ownership. So even under its section 59, it states that the certificate of title is conclusive evidence of ownership, making it difficult to challenge registered interest unless fraud is proven. So if you have a land title, someone cannot actually challenge your interests on land unless you show that you actually got that land in a fraudulent way, like you did not get it in the right procedure. You did not,
yes.
Probably, yes. So when you have a land title, you have conclusive ownership of that land. Section 64 also provides for the issuance of replacement certificates of title in case of loss and destruction, because you find people, maybe someone's house may be burnt and the land title is in that house. So you have a right to go to the registrar and then you apply in a way, and then you probably tell them that, I lost my land title, and probably they can get you another copy, because remember, when you register, they also remain with copies of that same land title. Yes, because if you transfer it, that's why they say if you sell your land to someone, that person has also to go to the land registry to also change the names of the sole owner. You get me? Yeah. So it also provides for protection of registered interests on land. Then under section 176, it provides that registered land cannot be acquired through advance possession or unregistered dealings. So you cannot acquire land through unregistered dealings. It is very, 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 very clear. It also highlights that a bona fide purchaser for value without notice is protected. So a bona fide purchaser without notice is this kind of person who you can buy land from someone without knowing that there is some fraud involved.
Yes.
Let's say I buy land from you. I buy land from you, but without me knowing that you actually got that land fraudulently from some other person. So so that one says it shows that I am a bona fide purchaser. I got land from someone who probably got land in a wrong way, but there was no even I did all the due diligence to find out if you're the sole owner of the land, and it really showed that you're the sole owner of the land. So it was very hard for me to even know that you got that land in a very clear manner. So so that person also, it means that the person has gets ownership on land, like someone who got land in a proper way. Yes.
Okay. Before you continue, under that section of 176, is there a possibility of two people having land titles of the same land? Because we've had these cases.
Per the law, it is not allowed.
Okay.
Per the law, it is not allowed. But we have seen, the land boards giving people, we have seen people having, like 2 people or 3 or 4 people having land titles on the same land. And I have a feeling this is not the law is clear. It is not right. But these land boards, there is a way they play their funny games, and you find that a lot of people are having land titles on the same piece of land, and it really beats my understanding how it happens, but probably it's
in a corrupt way.
Yeah, it happens because of the corruption that we have. That is why we have such issues. You even find LCs knowing very well someone comes and purchases land, and then they sign for this person and another one and another one. Though if you got, it's very good. If you got, they can actually sue you for fraud. They can sue you for forgery. They can sue you for many cases. But the law is very clear. But like we said, theory. But in the practical bit of it, people are doing very different things. Yeah.
Yes.
Yeah. So the registration, we are still discussing about the Registration of Titles Act. Under this, we also have transfers and transactions of land in Uganda. There's a difference between under this. It stipulates that Section 92 governs the transfer of land by a registered owner. Transfer of land is transferring from. We'll talk about it in a way of like transferring land, like the ownership, like the names from one person to another. So Section 92 provides for the transfer of where one person buys and then another has to change the ownership names of land. And then also Section 139 also allows a person claiming an interest in registered land to lodge a caveat to prevent dealings without their consent.
Okay.
Yeah.
Thank you. To our dear listeners out there, if you are listening to Witness Radio, and those that are not yet listening to Witness Radio, you should definitely listen into and then get knowledge about land, because this is something that we all know that it's something very delicate and something that people's lives rely on. So if you do not have a Witness Radio app, just go to your Play Store, download Witness Radio app, and then you will be listening in live. And for those that are on our social media handles, you can find us on Twitter at Witness Radio, or call us directly at 041 4697221. Kindly do the needful if you need to understand more about land. We are going in for a short break. We shall be back.
Listen to Witness Radio and gain knowledge about land and environment injustices by communities.
Want to stay informed about land and environmental justice struggles? Tune in to Witness Radio.
Welcome back, dear listeners. We are talking about the Mortgage Act, and Miss Joan is going to tell us more about the Mortgage Act. Miss Joan, you're welcome.
Thank you. Welcome back from that short break. Yeah, now we are here to talk about we have talked about the Land Act. We have talked about the Registration of Titles Act. Hope you're still moving with us. Hope we did not leave you anywhere. Hope you're not left behind.
Yes.
Now we are talking about the Mortgage Act of Uganda, Cap 477. And under this Mortgage Act, it regulates the creation, registration, operationalization, and enforcement of mortgages in the country, And under this, it defines a mortgage as any charge or alien over land or interest in land for securing the payment of money or performance of obligation. Like I said, you can give your house or any property you have to the bank or the money lender or whoever you want to get money from as security, and that is called mortgaging. You're mortgaging your property for money.
Oh, this is what they call in Luganda okusinga.
Yes.
Okay.
Yeah, that is it. So the Mortgage Act will also provide or stipulate properly the creation of mortgages, and it says under Section 4 that a mortgage must be in writing, signed by the mortgager, and attested by witnesses. So like the way we go in when you go to the bank and you give in your property, they will always ask for guarantor,
Yeah,
Yes, so those are the witnesses that are needed. So Section 5, it also provides for the registration of titles, like the Registration of Titles Act stoplights, a mortgage must be registered to be effective. You must register it to be effective, so that whoever is trying to buy your land can actually know that there is a mortgage on this land. And people have a tendency of actually selling land when it has mortgages on it, which is very bad because it affects the new owner of land. So please, people should stop actually being that too much fraudulent when it comes to land transactions, and they have to be transparent, and so that they have to register whatever that is on their land, so that the new owner can actually know what is on the land before buying it. This one also allows mortgages over customary land with approval from the relevant customary authority or community leader for those people that are owning land under customary law, customary land tenure, and the land is not yet registered and do not have a customary certificate of land ownership. Please, they are allowed to go and mortgage the property, but with permission from the community leaders. It also provides for the rights and duties of parties. Under Section 9, it obligates the mortgagor to pay the principal sum, interest, and other charges as agreed. So if like there we see it in banks, if you're given time to pay that money, please you pay it with the interests that you're supposed to pay. It also grants the mortgagee the right to inspect the property, provided reasonable notice is given. The mortgagee has a right to actually inspect the property. The mortgagor has also a right to redeem the property by paying the full amount due before closure. So I know these days money lenders have a tendency. People actually mortgage things to them, and on the day of payment they disappear. My dear, if you disappear, and even if you appear after a week, and the person that has actually mortgaged or the mortgagor has full payment of your money, the person can actually redeem their property. So usually money lenders had that tendency of we shall call it stealing people's property.
They disappear once the full payment is done, and then
they usually have a tendency of the day you're supposed to pay money, because they'll be like, okay, you bring back my money, because some of them some people may not want to pay it in installments. So they'll be like, give me 3 months and I'll give you money. And the date you have agreed for that person to bring that money, they disappear. You look for them, their phones are off, and there is no way you can get them. But usually they do this with the intentions of trying to steal people's property. But it is very good to know that the Mortgage Act actually says no. If you disappear, even if you appear after a week or something, as long as I have your money, you must give me back my property. So that is something that also the Mortgage Act provides for. It provides for interest of mortgages. We shall look at under Section 14, provide for the interest must be reasonable and clearly stated in the mortgage agreement. Yes, the interest must be reasonable. These apps, I know they do not ask for interest. Those apps, online apps, those people, I don't know, that their kind of interest is overwhelming. You find someone giving someone 10,000 and you expect someone to give you back 25,000 within like 3 days. Something that is not reasonable enough, So, but it's
interest.
Yes, excess interest. That is, you find it like literally. If you look at it financially, you'll be like, this person will not be able to get this kind of money within this kind of period of time. Reasonably, if you to look at it. So the Mortgage Act says, please, for people who are mortgaging their property, the mortgager and the mortgagee, please kindly have reasonable interests, so that you're not there to just, I will not call it the true thing, but in a way, you're stealing people's money,
But nowadays people are also very wise.
Yeah.
When borrowing that money on those apps, when the time for payment comes, and it's time for them to pay back with interest, they throw away those lines and get new lines. Like it's sort of either way.
I know.
People are also not being honest.
I know, but
yes.
The only bad thing about some of the apps is, my dear, they can come for you. There is what they call defamation. They can come for you and you all over. They spread your picture all over. Yeah, or get to talk to all your people that please solicit this kind of money for this kind of person. So it is also kind of a bit tricky. It is so tricky. Please, our dear listeners, we are still discussing about the Mortgage Act of Uganda. So under this, we also it's under Section 17 of the Mortgage Act. It also provides for the registered land must be entered into the land registry. That mortgage over the registered land must be entered into the land registry. Unregistered mortgage are not enforceable against third parties. Yes. This applies where, when they talk about unregistered mortgages are not enforceable against third parties, is where you like Rita, I come to you and I buy land, or you buy land from me, and then you do not register it on your land title that there is a mortgage. You get me? So if another person comes to buy that land and there is nothing that shows that there is a mortgage, it does not affect the new owner. You get me? Yes, really? It doesn't affect them. So you and I have to deal with that mortgage without involving the third party. Okay. Yes. So it also provides for remedies of mortgages. Under Section 20 of the Mortgage Act, allows the mortgagee to sell the mortgaged property after giving notice to the mortgager, just in case the mortgager fails to pay money. Then the person that has actually given you the money, the mortgagee, can actually sell that property and get their money after giving you notice, and must be reasonable notice. Yes. Yeah, it must be reasonable notice. So Section 22 also provides for a mortgagee can appoint a receiver to manage the mortgaged property. Also, Section 23 provides for foreclosure is permitted as a remedy for the recovery of the loan. We shall also, under the Mortgage Act, also provides for the protection of the mortgager. So this one, it prohibits, under Section 26, it prohibits the mortgagee from exercising the power of sale without giving the mortgager a 21-day notice. The notice we have been talking about, it must be reasonable notice, 21-day notice of, my dear, I have waited for my money and it is not coming. So I think I'm going to sell this property so that I can get my money out of it. Also, when you look at under Section 27, provides for the mortgager can apply to the court of law for relief against enforcement of mortgage terms deemed oppressive. This is where we talk about there are some mortgages or people that lend money, but their terms are very, very, very tight. They are very like they can frustrate you, and you feel like, no, this is not right in one or another. Oh, there are people who keep saying that, money lenders, let's say, who keep saying, if you run this kind of period of time without paying me, actually the interest doubles. It doubles more than you're required to pay. So here, the mortgager has a right to go to court and seek for relief, from the mortgagee, from the lender, Yes. Ensure the mortgage shall sell the property at a market value to avoid exploitation of the mortgager, like now we see. But sometimes, I don't know, it really saddens where you see there's a time where you see the bank taking someone's property, and for the time they've taken it, let's say the person has probably bought land in maybe 2025. You find that within 2028, the interest of land, the value of land will have actually appreciated. Yeah. Like it will have gone high. But you find the bank actually selling your property at the cost of the money. You get me? That you actually borrowed from them. You get me? It really breaks our hearts, but usually it happens. It really happens. So we are still discussing about the Mortgage Act, and under the Mortgage Act we also have discharge of mortgages. Under Section 30, the mortgagee must issue a discharge document, and the registrar of title must cancel the mortgage entry in the registry, just in case. That applies where actually the mortgage was registered. Yes, so when the person pays the money, they cancel the mortgage, and now it no longer affects new owners in case the owner of the land wants to pass on the land to someone else. It also provides for dispute resolution, just in case the mortgagee and the mortgager have issues. they can sort out their issues, through court or an alternative dispute resolution method, any that may come. So that is all we had for. That is what we had for. That is what is entailed in the Mortgage Act.
Yeah, in the Mortgage Act.
I know we may have talked about it in a summary way, but like I have assured you, we shall
go deeper.
dive deep, yes, to know what more it talks about. And I think next we shall be going to the Land Acquisition Act, Cap 226 of Uganda, and this one provides for legal framework for the government to compulsorily acquire land for public purposes while ensuring the right of affected persons are safeguarded. So below is when we are to look at and like I was saying, when the government is acquiring land compulsorily, it must follow the laws where there must be consent between the landowner and the government. There must be adequate compensation. Yes. So the government cannot just acquire land just like that. And it will provides for a compensation. It must be adequate, prompt payment of fair and adequate compensation. It also provides for dispute and appeals just in case the government and the landowner have not agreed. So you have a right to actually report the matter to court, or so that disputes are solved, and you have a right to appeal just in case you find that at any level you've reported to, you're not satisfied with that decision. You can appeal to a higher level so that you justice is accorded.
Yeah.
Yes, that is what the Land Acquisition Act actually covers so much, So for today, that is all that we had in regards to the laws governing land management in Uganda. The laws that are left out, we shall be discussing them in the next program when we get to meet again. Thank you.
Well, thank you, Miss Joan. We've really benefited and hope you have been listening in and you have benefited a lot from today's topic and discussion. Please, if you have more questions about whatever that we have discussed about, kindly go onto our social media handles that I've been reading, and you'll find all those details, or you could listen in to the next program of Luganda that will be aired. For today, we would like to say thank you for listening in to Witness Radio Uganda. Before we are out, our dear listeners, in case you are affected by land evictions, please reach out to Witness Radio. You can call our office at 041 46 97 221. You can visit us at our website at www.witnessradio.org. On our land evictions portal, you will find detailed guidelines on how to report these cases. That has been all. Kindly, John, say bye-bye to our listeners.
Well, thanks for staying tuned in with us, and thanks, Rita, again. Once again, thank you for this opportunity to give me this platform to allow me share knowledge with the citizens of Uganda. I really do appreciate it. Thank you very much.
Okay. As for now, allow me say bye-bye, and until next time, I remain your host, Rita Babide. Until next time, bye-bye.
Bye.